Okay. So just to begin, what are we talking about when we're talking about manufactured homes? There is a specific definition within the Manufactured Home Community Rights Act. It refers you to a section of the 1976 HUD code. This is the specific definition. So when we're talking about manufactured homes, many times we're not talking about homes that are mobile. A lot of them can't be moved, although there are some, and we've had clients that have been able to move their homes. And sorry, it was getting stuck there. So one unique thing about manufactured homes is the way that they're titled and the way that they're taxed. So in Pennsylvania, a manufactured home is titled as personal property or vehicles. The titles are run through PennDOT. That's where people get their titles and transfer their titles, but they're taxed as real estate. And the legislation has been, well, at least drafted, trying to make manufactured homes real property. We don't know how that will work, but there's also a slide within our presentation talking about these unique vulnerabilities, and we're going to get to a lot of these, and that's why I'm kind of moving through these first slides pretty quick, just because a lot of this is going to come up throughout our presentation. So what we want to get to is the law that applies to manufactured housing, and those laws, the two main laws that apply, are the Manufactured Home Community Rights Act. This is often referred to as MHCRA or MHCRA, or the Mobile Home Law or the Mobile Home Act. If you're writing it on a, in a pleading, it's the Manufactured Home Community Rights Act of 1976. That applies to manufactured homes. It's later in time than the Landlord-Tenant Act, but the Landlord-Tenant Act also applies. And then we're going to get into the specific definitions of, when you hear us throughout the presentation refer to a resident. A resident is someone who owns and lives in the manufactured home and rents the lot. So that's what the MHCRA applies to. So the regular Landlord-Tenant Act will apply to any tenant residing in a manufactured home park, but all of these additional laws that we're going to talk about today that fall under the MHCRA apply only to residents, who are people who own the home and rent the lot. The MHCRA, importantly, does not apply to a person who rents both the home and the lot. And just another term that you're going to see later in the presentation that's going to be important is rent is defined in the MHCRA as ground rent for a manufactured home space. And you'll see the reason that that's important versus service charges and other charges a little later in the presentation. I think the biggest, most important feature, I guess, of the MHCRA is that it creates for-cause evictions. So unlike private landlord-tenant situations where you can simply end a lease, it defaults to month. If people don't have an unexpired written lease, a private landlord could choose to end their lease at any time. That is not the case when someone is a mobile home resident. So they own the home, rent the lot. They can only be evicted for one of four reasons: non-payment of rent, 2 violations of the community rules within a 6-month period, change in use of the community, or termination of the community. And the 2 that we most often see are non-payment of rent and rule violations. So the Landlord-Tenant Act also, that was earlier in time. Again, that was 1951. The Landlord-Tenant Act also specifies that a community owner can't recover space at the end of a lease so long as the resident is complying with the rules, paying the rent. So since the Landlord-Tenant Act, there have been these additional rights that apply to someone who owns their mobile home and is residing in a manufactured home community. So the notice requirements are just a little different for non-payment of rent and for violations of community rules, the two most common issues that we see. I haven't never had a park closing. I don't know if Cici has ever dealt with park closings or changes of use or anything like that. But all the time we see non-payment of rent cases and community rules cases. And so with any resident of a mobile home, there have to be the first notice is what we call a conditional notice. So they should be getting at least two notices. And that's the argument that we would make, that if it's non-payment of rent, they have to get this first conditional notice that allows them an opportunity to cure. If it's during the summertime, it's a 20-day notice. If it's during the winter time, September 1st to March 31st, it's a 30-day notice. And then the MHCRA also allows eviction if they do fall behind on rent again within a 6-month period. Another really important thing, a difference from regular landlord-tenant cases, is the type of notice that has to be given, or the method of service. It has to be by certified registered mail. The MHCRA requires that. A lot of times manufactured home community owners don't do that. They tape it to the door, they hand deliver it, but they don't send it by certified or registered mail. When it's a violation of the community rules, that first conditional notice is basically the warning. You violated the rule for yard upkeep or some other community rule that they have. And now if you do that again within 6 months, they can move to evict you. And so that first notice, again, is a conditional notice, has to be served by certified or registered mail. It allows an opportunity to cure, to stop the rule violation. It's only when they commit a second or subsequent rule violation within 6 months that the owner could then proceed with eviction. We would argue that the rule has to be the same. And I think we'll get to that in another slide. But what we always argue are that both of the laws apply. So the Landlord-Tenant Act applies and the MHCRA. So you need to get at least those two notices. The notice to quit would apply, but a lot of leases will waive the notice to quit. So that's another important thing to pay attention to in these cases. But it's like the first thing that you want to focus on with a manufactured home client when they're when they call and they say they're being evicted, or a lot of times they'll call after they get notice that there's a hearing scheduled. You want to go back and look at those notices. Were they given the proper notices? Were the times correct? The method of service, was it correct? And then if the lease doesn't waive the notice to quit under the Landlord-Tenant Act, did they also follow the rules under the Landlord-Tenant Act? So we did, when we were preparing the presentation, we did find some case law that out of Beaver County where the court found that they can begin the eviction automatically right after the second or subsequent violation of the rules without further notice. So all that they have to do is send the certified registered notice first to the resident saying you violated the rule. If there's a second or subsequent, we're going to move forward with eviction. When the second or subsequent violation occurs, that's it. They move forward with eviction as long as it's within 60 days. The next thing that the client would be getting would be a recovery of real property hearing notice. And the Common Pleas Court in Beaver County said that's all that the MHCRA requires. We would argue that it doesn't. There's a second notice must be given. If it's not waived in the Landlord-Tenant Act, a notice to quit is required under the Landlord-Tenant Act, but also that the first notice, that the MHCRA requires two notices. The first one, being conditional, giving them an opportunity to cure, and then a second notice telling them, no, you've now committed a second violation. So in Malvern Courts v. Stevens, which was a Superior Court case, the court did look over the notice requirements, why the notice requirements are there, and uh, they found in that case that if a park owner doesn't comply with all of the provisions of MHCRA, then you can't commence the eviction. So, like I said before, one question that comes up is, does the rule violation have to be the same? So if they get a notice, we argue that it would, under the Malvern Courts case, that it does have to be the same, because otherwise they didn't get that first conditional notice, and that's the purpose of it, is to give them an opportunity to cure. So if you're being told that you're violating the rules because of yard upkeep, or then another rule for not having siding on your home or something. There's so many different rules that apply in manufactured housing cases. These are they're like just those two examples are just completely different things. If somebody were to correct and fix up their entire yard, but they didn't, put on the proper siding, or, get rid of unauthorized persons or vehicles or whatever, there is no more opportunity to cure. That effectively removes that opportunity to cure. So we would argue it has to be the same. You need to get notice about any breach of the community rules, and a second or subsequent violation of that same rule needs to occur within 6 months.
And then I think also, if you can move to the previous slide, that we kind of tried to look for definition of second or subsequent, and we found a definition in a criminal proceeding. So we're thinking maybe as a different way to approach this and convince the judge, because the definition in a criminal proceeding is a crime committed by someone who has already been convicted of the same or similar crime. So and the statute basically mentions the same wording, second or subsequent violation of the rule. So that's something extra that you can add in your argument, that it should be the same rule that needs to be violated for the eviction to start, for the park owner to start the eviction process.
Right. And so we're just going through some of the defenses. Like the first one are those notice requirements, and I think that's one of the more common defenses that we raise, especially with the magistrates. And one, just like an advocacy note, I always take a copy of the MHCRA. Okay, I always take 3 copies with me whenever I go to a landlord-tenant hearing, an arbitration, a bench trial. I have at least 3 copies of that act. I highlight the sections with the arguments that I'm making, and then I can give a copy of the act to the magistrate, to the opposing party, and say, like, here it is. Like, I'm not just making up that it has to be by certified registered mail. Like, this is exactly where it says that it has to be by certified registered mail. And it was, I've talked with some magistrates who, I guess they don't get much training on the specifics of the MHCRA. They, a lot of them vaguely know that different rules apply or additional rules apply, but another defense that we use is unequal enforcement of the rules. I actually used this in a case. Me and John Bird went and took pictures of the entire park because it was they were alleging a violation of the yard upkeep. That's why I keep mentioning that rule, because that was one of the rule violation cases that I had. And the park was absolutely a mess. Every yard had, like there was a toilet in somebody's front yard. And they were saying that our client was being evicted. $0 rent. Rent was all paid up, but he's being evicted just because he has garbage around his yard and not, for yard upkeep. And we ended up settling it with the property manager, and he stayed there for several years later, and then he was evicted for non-payment of rent, I think in a second case 4 years later. But we kept him there for a long time. They weren't able to evict him for the yard upkeep issue. But we argued unequal enforcement of the rules in that case, because the MHCRA requires that the rules be uniformly applied to everyone in the park. So the rules also can't be unfair or unreasonable. So community owners can establish all sorts of rules, and they do establish all sorts of rules. They have to post the rules in a conspicuous place where people can access them. They're supposed to include them with written leases. They're supposed to deliver them to the mobile home residents. A lot of times our clients don't have a copy of these rules. They don't know where the rules are. They don't know where to go and view them. They just get served with a notice that says you violated rule whatever of the community rules, and we don't know where the community's rules even are. But the rules have to be fair. They have to be reasonable. They can make all sorts of rules related to health, safety, and upkeep. But if you find some crazy rule that seems absolutely unfair or arbitrary or just wacky, yeah, you should argue that Section 4 of the MHCRA doesn't allow unfair or unreasonable rules. They have to be fair, reasonable, or related to the safety somehow. So this is again just this is where you bring the copy of the MHCRA and show the judge that if they're not applying the rules equally, here are all the pictures of all of the other manufactured homes in the park. Look at these properties. They can't evict them if they're not evicting everyone else. I think their argument in that case, I think they replied that maybe they are evicting them, but they didn't really say one way or the other. So some case law on unfair and unreasonable rules, the rule that all vehicles must be registered and in running condition was held to be reasonable, to prevent abandoned vehicles on the property, something like that. So that's Beaver County Court of Common Pleas. They're not too friendly, I guess, to mobile home residents. Requiring a switch from oil to propane heat was arbitrary, absent a factual basis for safety concerns. In the Adams v. Palmyra Homes case, that was out of Lebanon County. So there's a county that may be a little more friendly to mobile home residents. The next defense is retaliatory eviction. So if a manufactured home resident asserts any right under the MHCRA, there's a presumption under the Act that an eviction that occurs within 6 months is retaliatory. And that's also not allowed under the MHCRA. It's a rebuttable presumption, but an owner that turns around and begins eviction proceedings within 6 months of a resident coming forward and trying to assert one of their rights, in which we're going to get to resident rights in a minute. And I'm going to turn it over to Cici to cover some other issues in manufactured house cases before we get to that list of rights that they have.
Thank you, Dan. So as we are dealing with manufactured home cases, we see some issues popping up from time to time. So we wanted to discuss that. One issue that we see is when the park owner provides some services to the residents, like water services or sewer services. And you see that in parks where they have a well. So basically, the park residents are being serviced with the water from that well. So there is an implied warranty of habitability. It's kind of like the same that you have in a residential lease, but it's limited because it applies only in cases where, again, the community owner provides utilities or other housing services. So the case that established this limited implied warranty of habitability, it is a Supreme Court from 1998. You have it right there, Staley case. And in that case, the court discussed about this warranty and basically says that it applies the same way it applies in a residential lease. And it mentions actually the Fuchs case from 1979 and basically states that a material breach by one of these obligations will relieve the obligation of the other party as long as the breach continues. So basically, in that case, the resident was withholding the rent because he did not have water services. So the court decided that that was perfectly okay, and it created this implied warranty of habitability. Obviously, you have to do the same, you have to go through the same process that you will go in a residential lease, meaning that you have to provide notice of defect to the park owner, and you have to allow the park owner some time to resolve the issue. So you do the same analysis that you do under the warranty of habitability in a residential lease. So that's one issue that we're seeing. The next one that we're seeing, it's adding utility charges or additional cost as additional rent. And interesting enough, yesterday I just received a complaint from an attorney for a park, for a mobile park, that actually had this additional rent. So Dan, if you could move one slide, because I added this. So this is a notice to quit. It was kind of perfect because it provided me material for today's presentation. So I just added this morning. So this is a notice to quit that was provided to my client for cost of repairs, and it was added rent. This is the letter that was provided, and you have the attorney right there on the bottom. It was served on December 2nd, 2024. And basically it's for some cost that the park owner has incurred for doing some repairs to the water pipes. And adding $1,000 as additional rent because of so alleged my client not allowing the workers to come into her yard, and they had to do extra work that cost the park owner $1,000. As you can see, they actually follow the notice to quit because it was December 2nd, 2024, so it was winter months. So they provided her with a 30-day notice, and it was sent by certified mail. Obviously, they did not follow up with the notice to quit out on the Landlord-Tenant Act. They just went and filed for eviction at the local magistrate. And she won by herself. She didn't know how to represent. So now we are where we are. We helped her with the appeal. So now I'm in the process of filing a response to this. So we can go back to the previous slide, Dan. Okay, now our position is that any kind of cost and utility charges cannot be added as rent. Why? Because rent is defined in the statute as ground rent for a manufactured home space. You also have a different definition for service charges, and you have it right there. Okay, so Dan, I think you went under the inbox, disappear. All right, thank you. So you can move forward with the two slides. So based on the definitions alone, the rent is just ground rent. Thus, adding any other charges as additional rent should not be allowed. Now, why it matters? Because owners could charge late fees for unpaid rent. So for that $1,000 that supposedly my client owns as additional rent, she's being charged $25 extra. How do you address this? If litigation has started, like in my case, you should file an answer with no matter and counterclaim, which I intend to do. seeking treble damages and attorney fees for violation of the unfair trade practices and consumer protection law. If there's no litigation, you should file an injunction. Okay, so that's what I wanted to discuss about charges as additional rent. Also, we see sometimes in some cases where the park owners are trying to increase the rent. Especially we see in cases where we actually don't have a written lease, and we're going to get to that part as well. But we see park owners trying to increase the rent, and the statute is very clear. The rent can be increased only once every 12 months. It doesn't matter that you have a month-to-month lease. You can only increase it once in a calendar year. There's no limit on the amount that you can increase, so there's no cap. But you only are allowed to do it once. You also need to give 60-day notice to your resident as a community owner. And the resident has 30 days to accept it, or let the community owner know that he's not going to accept it. And at that point, you're going to have 30 additional days to move out or sell your home. There is a current law, I guess, and you have there the citation, and it's in the House right now, that will impose an annual increase tied to the consumer price index. But we're not sure where this is going to go, so we didn't want to provide too much information on this. We're not sure if it's going to pass or not. Okay, so next issue that we're seeing, and actually I'm seeing in this case that I just showed you, which is basically leases. What kind of lease do you need? So the Manufactured Home Community Rights Act is pretty clear that you need a lease to be in writing. It can be a month-to-month lease, unless it can be for a longer period, but it needs to be in writing and needs to be renewable. Issues that we see with this. If your client has a verbal lease, could a manufactured home resident be evicted based on that? Our position is no. The lack of a written lease should be used as a defense to avoid eviction, because you don't know what the terms of the lease are, right? Also, another issue that pops up sometime is if a resident could be evicted for refusing to sign a lease if rent is paid and no rules violations. Our position is also that no, because refusing to sign a lease in itself is not a ground for eviction. Okay, so as long as you pay your rent and there's no rule violations, then the community owner should not be able to evict you just on the ground that you did not sign the lease, that you refused to sign a lease. However, if you breach the lease that you refuse to sign, you could be evicted. So even though you refuse to sign a new lease, you are bound by the terms of that new lease or extended or renewed lease. So as we were discussing, preparing this training, we really don't see any reason why you would not sign a new lease if offered. Because at least you have a copy of the lease, you know what your rights and what your obligations are. So only remedy if you don't agree to the new lease is basically you're going to notify the owner that you're not accepting the lease, and then within 60 days just make arrangements to vacate the community or to sell or relocate the manufactured home. And okay, this is another issue that we're seeing, especially in Luzerne County. And this example was taken from the same complaint that I received yesterday. So there was no lease. The attorney actually pled in the complaint that the parties were working on an oral lease, which we know that shouldn't happen, and attach the community rules to the complaint. So I kind of copied a little bit of community rules that were basically effective August 10, 2023. And it had like 23 sections, paragraph. And in the end, it was a thank you for everyone for your cooperation. It had a company name and then the president and vice president and their signatures. No signature of the homeowner, of the resident, just signatures of the president or vice president. So sometimes we see park owners trying to use the community rules as leases. And our position is that that shouldn't happen. That provided that, because community rules are basically rules that have to be disclosed to the resident. But provided the disclosure of fees and other disclosure of rules does not waive the park owner's obligation to provide a written lease. And why am I basing this on? I'm basing on section 398.6 that says disclosure of fees. And basically it's pretty clear, the statute is clear. All rent, fees, services, charges, assessment, and so on shall be fully disclosed in writing prior to the manufactured home community owner's acceptance of any initial deposit, fee, or rent, and prior to execution of a lease. So my argument is always that based on reading of the statute, they have to provide a lease. Provided the community rules is not enough. So that's going to be my argument in this case as well. Now, we wanted to add some other issues that might show up in manufactured home, and I already discussed this basically, which is the requirements for the new lease and lease renewal and extension, and the fact that the community owner must give 60-day notice of intent, and the resident has 30 days to accept or notify the owner to vacate, and then another additional 30 days to relocate. And there's also this proposed legislation that would increase notice time. There's the same legislation that's in this House right now, but we're not sure what's going to happen with that. So there's specific disclosures for leases greater than 60 days. And you have here basically what they have to disclose, like the manner in which the lot rent will be increased, factors that may affect the amount of lot rent, rent history for the past 3 years, history of utility payments for the last 12 months, and so on. But honestly, what we see in our communities, we see basically month-to-month written leases. If sometimes we see just oral leases with rules attached.
Right, with a few papers.
And few papers. There are actually few papers, right.
Rarely do I get a manufactured home resident client that comes and says, oh, here's a copy of the lease. Like, I have a copy of the lease, and I have a copy of the rules, and I have the disclosures that are supposed to be provided to me. I don't think I've ever had a client with all three of them. Sometimes I've seen community rules, sometimes I've seen leases. I've never seen the disclosures.
So Dana, I'm not sure if you want to talk a little bit about residents' rights.
Yeah, I actually have a case right now that's going on with a client that's trying to sell her home, and she's saying that the park is refusing to allow her to sell the home. And that's one of the resident rights under the MHCRA, is that you do have the right to sell your home. The only thing that the park can do is require an application and an approval of the buyer or whoever the new resident is going to be. But the MHCRA also says that a manufactured home community owner can't unreasonably withhold anyone's permission for anyone to reside in the park. So they're not allowed to charge any entrance or exit fees unless it's the owner has those as actual costs. Cici already talked about the written lease requirement. And then we were talking about, when we were preparing the presentation, we were discussing like what remedies does my client have if that's the case. I'm waiting to hear from the park and find out what their actual position is, because my client owes rent on the property. She hasn't paid lot rent in a while. She wants to sell the home, satisfy the lot rent, and be done with it. But she's saying that the park is preventing her from doing that because they're telling the buyer that if they buy the home, they're going to have to move it out of the park. And that's not true. So we don't know what to do, what the remedy would be in that case. Either injunctive relief, I think that's what we pretty much settled on, because contacting the Attorney General, the district attorney within the Manufactured Home Community Rights Act, it says that they are that they're responsible for enforcement of the provisions of the act, and telling a client to contact the Attorney General or the DA's office, I don't think has ever gotten them anywhere. So, not that you shouldn't do it, file a complaint if your rights are being violated in a manufactured home park. Certainly file a complaint with the Attorney General. But I think we might have to file an injunction if that's truly the position of the park, that they will not allow our client to sell her home just because of unpaid lot rent. Like the home is worth a lot more than the unpaid lot rent, just for that case. There's also a newer section of the MHCRA that relates to rights that a resident has if they're selling or closing the community. So if a manufactured home community owner decides that they're going to close the community or they're going to sell it, and it's going to be repurposed for whatever reason, they have to send out notices. And importantly, they must purchase any manufactured home. If you see the last bullet point under, section 11.2, the owner must purchase any manufactured home of the residents who are unable or unwilling to relocate at their appraised value of $2,500, at their appraised value or $2,500, whichever one of those two is the greater. So it's either the value of the home or $2,500 if the home is worth less than $2,500. But that's what has been added to the act to protect mobile home residents if the park owner decides that they're just going to close the place. And also, as part of that amendment, they added that notice needs to be sent out to any organizations who have basically signed up to receive notice of park closures. And one of those is, the PA Housing Finance Agency and CJP have to receive notice of any park closure. That a park resident also has rights after abandonment. And so when we talk about abandonment, there are two ways that a manufactured home becomes legally abandoned. One is voluntary abandonment. So if the resident just decides that they're going to leave, they have to provide something in writing saying that they are leaving, they're abandoning the home, they want nothing more to do with it, and the park owner can do whatever they please with it. And the other way is an involuntary abandonment. That's determined by an MDJ through they actually issue an order of abandonment. And that's only after a judgment for possession and execution of the order for possession. So there has to be an eviction, a judgment for possession, they have to execute on the order for possession, and now that the home is abandoned, they can begin by giving notice. The 60-day notice of removal, they have to give to the resident and let them know that they have 60 days to claim the home and remove it from the community. And that if they don't, it could be sold or it could be discarded if the costs of a sale wouldn't justify having the sale. And if it's not removed and it's left abandoned, then that's when the park owner can go to the MDJ and request for a determination of abandonment. And once they get that, then the home is considered abandoned. The other rights that they have are to guests, visitors, and goods and services. Some park owners will have community rules that restrict guests, that unreasonably restrict guests and visitors. I mean, they could require anybody becoming a resident of the park to have to actually be added to the lease or apply to become to live in the park. But for any visitors, overnight guests, things like that, they can't require that, people are signing in or signing out, or that they have prior approval of guests and visitors, especially for business services and things like that. The manufactured home it meets the definition of a multiple dwelling premises under the Landlord-Tenant Act. And under the Landlord-Tenant Act, if it's a multiple dwelling premise, then you have the same right: social guests and visitors for reasonable periods, and business visitors and community owners can't charge fees or additional rents. And this, like all of the other rights, are not waivable. The right to participate in a tenant organization. So the park owner can't refuse to renew or say that he's going to evict if a group of tenants gets together and decides that they're for the purpose of enforcing their rights or just having their own tenant organization. I know one of our manufactured home parks has a very active Facebook group just for residents of the park. When they were having a big water issue, I was able to find out a lot of information because they allowed me to join that Facebook group. And so I was able to, see what all of the residents were saying. We already talked about the MHCRA's anti-retaliation section. So if they were to form a tenant organization, the park owner can't turn around and move to evict them. If they do within 6 months, it creates a rebuttable presumption that it's retaliatory. And then the last right, but one of the most important ones, is the right to not have rights waived. And so one thing previously, I had mentioned that one of the notices that's required is under the Landlord-Tenant Act. Like the same Landlord-Tenant Act would apply. The same notice to quit requirements would apply. In addition to the notices required under the Manufactured Home Community Rights Act. And Cici was looking at a lease that actually waived the notice to quit. And so the argument that I would make would be that the MHCRA doesn't allow any rights or duties to be waived. And that is one of the rights to, even under the Landlord-Tenant Act, that's one of the rights that a manufactured home community resident has, or manufactured home community lessee in this section. It says any agreement attempting to limit those rights is void and unenforceable. So I would say that's one of the important rights that protects a tenant, would be a notice to quit under the Landlord-Tenant Act. And so we talked a little bit about enforcement. As far as remedies are concerned, the Attorney General and district attorneys have authority under the MHCRA to bring actions against park owners. Yeah, I'm sure it happens. Like I said, we don't get very far when we tell a client, call the Attorney General, call the district attorney's office. But what a mobile home resident also has is the right to pursue a private right of action, and that any violation under the MHCRA is a violation of the Unfair Trade Practices and Consumer Protection Law. So that's included within the MHCRA. So under section 16.1 of the MHCRA, it plainly states that any violation of this act will constitute an unfair or deceptive act or practices under the UTP-CPL. And so any violation of the act, not having a written lease, unequal enforcement of the rules, improper notices, anything like that, I will always include as a counterclaim if it's, if we get to the point where we're before common pleas and we're answering their complaint, any violation of the MHCRA, I will include a UTP CPL counterclaim alleging that whatever section was violated and that it is a claim under UTP CPL, which also allows attorney fees payable to North Penn Legal Services and treble damages and all that stuff. So a lot of times, and I always explain to a client that even though I'm including it and I'm arguing that they should receive all of the rent that they've paid all the way back to the time of the violation, that they should not expect a court to award that, just trying to control their expectations. And it just becomes a good bargaining tool, like it gives us some leverage in negotiating with the other side and trying to, prevent eviction for whatever, the rule violations were, or non-payment of rent, or whatever the case may be. It gives us some leverage to negotiate and try to keep the person there, not to get them, the last $60,000 in rent that they paid over the last 10 years. Other laws that can apply are any, environmental protection regulations that could apply to the water and sewer systems. Those are most often provided by the community owner. I mean, the community owner has to provide utility hookups, but a lot of times the community owner is charging the tenant directly, like they're for water and sewer services. And local codes and ordinances. Yet some might have codes that apply specifically to the manufactured homes. And then there's also other things, like trash removal and private access to private roads and stuff.